Hello all, this is Keerthana, Assistant Professor, Department of Commerce. Today I am here to present a lecture video on mode of discharge on the subject commercial law. The discharge of contract is characterized as the end of agreement or an arrangement made by a couple of parties which results in the failure in performing or playing out the obligations referenced at the hour of making a contract with the acknowledgement of all the parties with free consent. Subsequently, the commitments might be legal or contractual or performance or even operational. In commercial law, the discharge of contract refers to the termination or completion of the contractual obligations between the parties involved. First mode is performance. The most common way a contract is discharged is through performance. This occurs when both parties fulfill their respective obligations as outlined in the contract. Once performance is completed according to the terms of agreement, the contract is considered discharged. And the second mode is agreement. The parties may mutually agree to terminate the contract before performance is completed. This can be done through a new agreement or by way of mutual rescission, where both parties release each other from their obligations under the original contract. And third one is impossibility of performance. Sometimes performance may be excused due to factors such as impossibility, where performance becomes objectively impossible, impractically, where performance becomes exclusively difficult or costly, or waiver, where one party voluntarily relinquishes their right to performance. And next is lapse of time occurs when unforeseen events make it impossible to fulfill the contract's obligations. These events are typically beyond the control of either party and make performance fundamentally different from what was originally agreed upon. In such cases the contract may be discharged. And the next mode is operation of law. Certain events such as death or capacity of the parties, illegality of the contract, or a change in law may lead to the automatic discharge of the contract by operation of law. Next is breach of contract. If one party fails to fulfill their obligation under the contract, it may lead to a breach. Depending on the severity of the breach and the terms of the contract, the non breaching party may choose to terminate the contract and seek damages for the breach. And the next is frustration. Frustration occurs when unforeseen events make it impossible to fulfill the contract's obligations. These events are typically beyond the control of either party and make performance fundamentally different from what was originally agreed upon. In that case, contract will be discharged. Next, accord and satisfaction. The parties may agree to substitute a new obligation for an existing one. This is known as accord, and once the new obligation is performed, which is satisfied, the original contract is discharged. And the last one is performance excused. Sometimes performance may be excused due to factors such as impossibility, where performance becomes objectively impossible, and impracticability, where performance becomes exclusively difficult or costly, or waiver, where one party voluntarily relinquishes their rights to performance. These are the modes of discharge of contract. First is by performance, and the second is by agreement, and the third is by impossibility of performance, and fourth is lapse of time, and the fifth is operation of law, and last one is breach of contract. Thank you. Hope the session was useful and informative.